that the Cambodian genocide has had. And secondly, I'm not sure that we need the General Assembly to motivate Bangladesh to get this going. I think Bangladesh can do this, wants to do this on its own, whereas the Cambodian government was very reluctant to do it. And the political configuration is very different as well, that the powers that wanted the Cambodian government to bring its perpetrators to justice are very different from the political configuration that Bangladesh would be faced with in the General Assembly if it tried to get a resolution through the General Assembly. So that it strikes me that the most immediate practical thing is to work through the 73 laws, cumbersome as that might be, because you are dealing with an old law and just a local law. But in terms of your questions of who, what form, what law, and what procedure, my answers very briefly are, in terms of who, you go for the leadership as best you can. I mean, obviously, the leadership, many of them are in Pakistan, and even many of them in Bangladesh. You're dealing with something that's 40 years ago now, will have been long dead. So you're dealing, I guess you could say, with junior leadership. But I think what you want to avoid is sort of bulking up the system with lower level people who are involved peripherally, because that would just clog the system up. In terms of what you charge them for, well, obviously you go for the more serious acts over the less serious acts. You go for the I would say the people who are doing things rather than the people who are aiding and embedding. That complicity has less of a priority than hands-on involvement in these acts. In terms of the forum, well, that's tied up with the legislation you use. I mean, if you're doing, I mean, that's a choice in terms of, do you go with a hybrid forum, do you go with an international forum, or do you go with the local forum? But if you're going with the local forum, then you go with the Tribunals Act. I mean, there is, of course, always the possibility. You don't actually need the Tribunals Act, the 73 Act, to use the Bangladeshi law, because every single act committed in the course of genocide was a common law offense. It was murder, it was rape, it was theft, and you could just use the ordinary criminal law of Bangladesh as well. But that I don't know that that would be appropriate, because it doesn't, it diffuses the offense. It may be useful for the lower level offenses, but I don't think that's appropriate for the leadership, because it doesn't give the visibility, it doesn't send the message, and also one has to be realistic that there are problems with the Bangladeshi courts simply in terms of getting results, getting conclusions. And some of these criminal law cases in Bangladesh in the ordinary courts can drag on for quite some time, and there's questions of procedure and fairness and so on. And with a smaller dedicated court, you can put in more resources and get a higher quality result. In terms of the law, I think it is worthwhile trying to, I mean, if you look at the law is kind of strange in 73 because it doesn't deal just with the genocide. It's kind of a disembodied law that it says it has to be for a crime committed in Bangladesh, but it doesn't have a time period. It doesn't refer to a particular offense. It obviously occurred in the context of the genocide, but you wouldn't know from reading the law that it's only about the genocide. And it talks about crimes against peace, and it's not clear that you can use that in the context of a civil war. Crimes against humanity, I'm convinced you can use in the context of a civil war, because there was that limitation in Nuremberg that it had to be conducted in the context of a war. But I'm not sure that was necessarily even part of international criminal law at the time, and I doubt if it was since. And you could war crimes. There's also an issue. Can you use war crimes in the context of a civil war? But realistically, what we're talking about is crimes against humanity and genocide, and those are available. In terms of procedure, there's lots of gaps in the 73 law. I don't think the law is defective. I don't think you'd necessarily expect a criminal law to have criminal procedure, but there needs to be a criminal procedure for an international criminal tribunal. I've made some suggestions myself in a paper that's in a book that's a sale outside at the table there, and I'll say this for Mofidul Hoque's benefit, not for my own, that it's only $10, and we encourage you all to buy it, and you don't have to read my essay. But in that essay, I do talk about the procedures that would be useful to have in such a tribunal. So those are my short answers to those questions.
Thank you. Professor Pati, let's come back to academia and have some views. You have some recent views from Berlin, in fact. So and you also have the Albanian perspective.
So let me start by thanking Dr. Kaplowitz for inviting me to this event, and I commend you in this really important conference to bring an issue that is long due to the fore. And talking about academia, I really second. What about now? I really would second the motion from one of the previous panelists that said that scholarly work is so much more needed in order to create the necessary visibility for the atrocities that happened in Bangladesh, and also, most importantly, to establish accurately a historical record that is necessary to be known not only to Bangladeshis, because they already know it. We heard the thrilling stories of the survivors today, and their heart-wrenching stories, just like the documentary, really tell us a lot. But how many of the rest of the community in the United States or elsewhere in the world really knows about that? And I think putting it in writing is what really matters, and analyzing it properly from all angles. Now, at the same time, we talk about international crimes, and once we mention them, we need to know what is this talk all about. And really, what these crimes have to do with are that they have reached a certain status that they have become peremptory norms out of which obligations flow for each and every country and state to prosecute such crimes. And these sort of crimes that really had shocked the conscience of mankind. And unfortunately, Bangladeshi atrocities are also one of these crimes. In terms of how we want to characterize them, Dr. Nunes rightly mentioned that, and so did Professor Rogers as well, Professor Clark, that sometimes we do hear the word genocide so often, then it sort of becomes a cliche. And then when we want to characterize events that really well deserve the term, it's sort of become a first name term. And also what we have noticed in the latest development of the international community, and this is long after 1971, particularly in the wake of the 1990s, I should say, with the international criminal tribunals, first the two ad hoc tribunals for the atrocities in the former Yugoslavia and those in Rwanda that are merely international tribunals. Additionally, the International Criminal Court, which actually would be good for Bangladesh to ratify it if we want to pursue further the rest of the activities and persecution of these atrocities. We have these international courts that have put an end to the notion of impunity. But at the same time, they have already laid grounds for a better understanding of both what we know as the ratione materia, so the substance of the crimes, but also in terms of procedure, how are we to proceed from there. And if we look carefully either at the statute or at the statute of ICC, for example, that replicates the notion of genocide in the same as it was in the Genocide Convention, and also if we look at the jurisprudence of the International Criminal Tribunal for former Yugoslavia or the jurisprudence of the Rwanda court, we realize that they have been sort of reluctant, if you will, to expand the notion of genocide. And this brings us to the issue that Professor Clark was mentioning. We have to think legally, once we bring this case for prosecution, how you want to prove it. And if I may kindly just bring the case of or a reminder here